And so for the first race, I'm going to call up Judge Richard Dietz and Judge Lucy Inman. And for the candidates, Lynette will hold up minutes left on your, thank you. Thank you. So in this race, the first one on the ballot is Judge Dietz. So please introduce yourself for 2 minutes, then Judge Inman, you'll get to do the same thing, then I'll ask you the question. Thank you.
Thank you. Come up to here?
Oh, that mic.
All right, well, good morning. It's not on. Here we go. All right, good morning, defense attorneys. Thank you all for organizing this forum. I'm Richard Dietz. I'm one of your judges on the Court of Appeals, and I'm running for an open seat on the Supreme Court, the seat of retiring Justice Robin Hudson. And the theme of my campaign is leadership for the courts. So I want to tell you what that means to me. I've spent my entire career focused on appeals. So I'm the only person you'll hear from up on the stage today who's a board-certified specialist in appeals. And I put my flyers down at the end of the hallway. They've got a long list of my experience as an appellate lawyer, but another thing you can see on there is courtroom sketches of me arguing cases in the US Supreme Court. And so take a look and see how well they did drawing the sketch of me. But the thing you'll see is I have the skills we need in the Supreme Court, but what I wanted to talk to you about in my 2 minutes is my vision for what I can bring to the key role of a Supreme Court justice. And that is, I'll work with my colleagues to help decide cases fairly, but also I'm going to work to create a stable body of case law for you, for your clients, and for the public so that you can read and understand our case law. And to me, that's the most important work of the court because I think that is essential to the rule of law in our country is to have people be able to understand the law. But my theme of leadership goes beyond just the work I'll do on the court. So I've also embraced technology with lots of programs to improve our justice system, an online CLE that I've created to help lawyers like you learn more about appellate practice, but also programs for high school students, for pre-law majors, and for law students to help the next generation of lawyers get the training they need to understand the work we do on the courts. I'm also very involved in some transformative changes that are coming to our court system, things like electronic filing, where there will be huge opportunities for us to make changes that will improve access to justice and reduce the costs and the burdens that we have in the legal system. And so my commitment to you is that when you elect me, you're not just going to get another Supreme Court justice, you'll get a leader for all our courts. Thank you.
Is this working now? Well, good morning, and thank you so much to this organization for inviting me and Judge Dietz to tell you about our race for the North Carolina Supreme Court. I've known many of you for decades as an advocate, as a trial judge, and as an appellate judge. So I will try to focus on something other than my background this morning as well. Judge Dietz and I have served on the Court of Appeals together for almost 8 years. You might be surprised to know that we have decided cases 100% of the time together. Each case we've had together, we've decided the same way. I haven't always agreed with all of my colleagues, and they haven't always agreed with me. I have written dissents. I have written not many, and I don't take them lightly, and always respectfully. But when I cannot honestly agree with my colleagues, and I believe a decision violates the rule of law or abandons precedent, I am going to write a dissent. Some of those dissents have been adopted by our Supreme Court. Some of my colleagues' dissents to my decisions have been adopted by the Supreme Court. That's what the appellate process is about. I want to emphasize that I believe politics has no place in our courts, and caution against what I see as a real partisan threat to the independence of our judiciary. Just last month, our Chief Judge, Donna Stroud, survived a primary challenge brought against her accusing her of siding with liberal judges and refusing to engage in partisan patronage. Thank you.
Judge Dietz and Judge Inman, you have both served on the Court of Appeals, as you have pointed out, and authored decisions in civil cases. Please share your personal philosophy about judicial activism and judicial restraint, and point to some civil decisions that demonstrate your judicial philosophy. And Judge Dietz, you'll have the first 4 minutes.
Sure. So I hear those terms talked about a lot, not just by lawyers, but I think by members of the public. And I think there's sometimes a meaning to the words judicial activism and judicial restraint that don't carry the meaning that we have as judges and what we think about. So Judge Inman and I both, I know, have the same commitment when we took our oath and joined the Court of Appeals, which is to follow the law. So the Court of Appeals is an error-correcting court, and what we're doing at the Court of Appeals is following the law. The court we're running for, the Supreme Court, is a court of discretionary review with a slightly different job. And part of that job is steering what we call the common law. So oftentimes the Supreme Court will be in the situation of creating some law that wasn't there before. I wouldn't call that activism. I think that's part of the genius of the rule of law that we have here in North Carolina and in America, is that we have a common law system. So I wouldn't describe making new law as activism. What I view the key difference between an activist judge and this concept of judicial restraint is understanding what our role is as the judiciary. And that role is we want to guide people to help them resolve their legal disputes fairly, and we want to allow people to understand what the law is. We communicate that through our written decisions. And so in our role as the judiciary, we have to avoid stepping into the politics and the policy that we often see coming from the other branches of government. Like Judge Inman, I'm very concerned about how politicized the judicial races have become. What I think we can do to show people that we have this judicial independence, that we're a separate branch of government, is really focus on how important it is, the work that we do as judges, where we're helping people resolve these legal disputes. We're following the law, applying the law, and in doing so in a way that the public can see and understand what we're doing. A lot of that comes from good writing and from good communicating about our decisions. But another part of that is being able to show the public that we're not getting into this kind of political activities and the political discussions that are going on in the other branches of government. And I think that's what feeds this idea that judges are, what are often called activists. So the idea that we're just sort of politicians in robes. And I think we push back on that by showing that we're leaders and that we spend our time as public servants and educating the public about the work that we do. So I'll give you a couple examples of that, because you asked for some examples in cases. So I've had a number of civil cases where I've read the case and thought, this is a really sad situation, what's happened to this person. And it's been heartbreaking for me to see what's happened in reading the case. But there wasn't a legal claim in the case. And in a case like that, and following the law, we dismiss the case, or we enter judgment in favor of the defendant who's been sued. And oftentimes you realize that means somebody will go without a legal remedy. But if there wasn't a legal remedy there, I can sleep at night, because our job is to look at those cases and say, what does the law require? And I think the activism that we do see sometimes from judges in the legal system is feeling like, I want to try to help this person. And let me see if I can strain to find a way to do that in the case. And when you read the body of case law that I've produced at the Court of Appeals, you'll see that's not what I do. You can expect certainty. I'll apply the law, and that means I'll be even-handed no matter what the result is, and I'll bring that commitment to the Supreme Court as well. So thank you for the question.
Well, I'm finding myself agreeing with just about everything Judge Dietz has just said, and I'm not surprised in that at all. And I do think that we both share a real passion for careful writing and making sure that not just the parties, not just the lawyers, but that the public understand how the court reached its decision. Judicial activism, you hear legislating from the bench, other terms to describe judicial activism versus judicial restraint. And it's different at the Court of Appeals than it is at the Supreme Court. And what that means is at the Court of Appeals, we are bound by the decisions of our own court as well as those by the Supreme Court. We are rule followers. at the Court of Appeals. And I think my record shows that even in cases, as Judge Dietz said, where you would think, I feel terrible that this is the result, I'm going to follow the precedent. Even if I think it was wrongly decided, I'm going to follow that precedent. And I have seen, I had one case I can recall in which I did not write the opinion. Judge Stroud wrote the opinion, and it had to do with a claim of sort of a Leandro-type claim for sexual abuse in the public schools. And one of our colleagues really believed that we were not bound by earlier precedent from our court. Judge Stroud and I did believe we were bound by it and applied it. The Supreme Court reversed our decision. The Supreme Court was not restrained by that earlier precedent. That's the latitude that the Supreme Court has. That is where you really have to think about, is a judge or a justice going to follow canons of construction and separate themselves from the emotion? I guess an example of a decision, or a couple of decisions that I've written, involve the separation of powers between the legislature and the governor in North Carolina. One of them most recently involved block grants. And the legislature, for the first time in history, reallocated some federal grant monies within the executive branch agencies, different from what the governor had written in his budget. The governor's council argued that this was unprecedented and wrong, and the legislature's council argued that just because it's never been done before doesn't mean we don't have the authority to do it. As a policy matter, did I agree with the legislature's allocation of a reallocation of these grants? That didn't come into it. It came down to an examination of our state constitution. And although I think many partisans would have predicted that I would have written a decision handing a win to our governor, I wrote a decision, a unanimous decision, which upheld the legislature's authority to do that. That is the kind of discipline that it requires for a judge and a justice to preside over some of the hardest fought cases in our state. I consider the facts and the law and honest analysis and nothing else. Thank you.